Good afternoon, everybody. Thank you for joining us here today. I am Joseph Benezia. I am the chair of Florida Rights of Nature Network, and I'm the operations director for Florida Right to Clean Water.org. These are the two organizations that are spearheading the effort in Florida to amend our state constitution to give all Floridians a fundamental right to clean and healthy water. Red tide in the last 30 years has exploded. It's more frequent, it's more virulent, and they last longer than they did historically. We have 50,000 tons of legacy phosphorus sitting at the bottom of Lake Okeechobee, exacerbating blue-green algae blooms. By the way, 35% of the lake is covered with a blue-green algae bloom at the moment. And we anticipate that down here in Southwest Florida, it'll be reaching us down the Caloosahatchee River, and it will do the same thing on the southeast coast via the St. Lucie. We have nearly 1 million acres and 9,000 miles of estuaries and rivers and streams, respectively, that are contaminated with fecal bacteria. Seagrass beds are on the brink of a death spiral. Indian River Lagoon has lost 46,000 acres in the last 10 to 12 years. No state has more acres of polluted water than does Florida. No state has lost more acres of wetlands than has Florida. 9.3 million acres. So that's why we are looking to amend our state constitution, giving all Floridians this fundamental right. We are here specifically today because very recently, two things happened that are likely to make threats to our waters and our aquatic ecosystems even more challenging, to make water quality worse. One has to do with a Supreme Court decision, and the other has to do with legislation that has come out of our most recent legislative session. So we have two experts with us today who can talk with authority about both these issues and tell us what we need to know. So I want to tell you a little bit about both our guests. The first guest that we'll be speaking to is Maya Van Rossum. And I'm going to read from their bios because they're too extensive for me to have memorized this. Maya is the founder of Green Amendments for the Generations, the national nonprofit organization dedicated to inspiring passage of green amendments in every state constitution across our nation, and also at the federal level when the time is right. Green amendments, a term that Maya coined in her 2017 award-winning book, Green Amendments, recognize and protect environmental rights on par with other inalienable civic and political freedoms. She is also the Delaware Riverkeeper for over 30 years. She has testified by invitation 3 times before U.S. Congressional committees, and she founded the Environmental Law Clinic at Temple's Beasley School of Law. Maya, thank you for being with us today. And I'll take a moment to also introduce Jane West. Jane is Policy and Planning Director for 1000 Friends of Florida, where she works with citizens to provide guidance on critical growth and development issues facing communities across Florida. She lobbies the Florida legislature to promote legislation for sound community planning that protects Florida's natural resources. Prior to joining 1000 Friends in 2019, she litigated precedent-setting environmental and land use issues in Florida. In both state and federal courts. She is an AV-rated attorney submitted to both the Supreme Courts in Florida and Maine, as well as the Southern and Middle Districts of Florida, the 7th and 11th Circuit Court of Appeals, and the U.S. Supreme Court. She was raised in Budapest, Hungary, before moving to Florida as a teenager. She served as chair of the City of St. Augustine Beach's Planning and Zoning Board and is currently a commissioner of the St. Augustine Port, Waterway and Beach Commission. Jane, thank you very much for being with us here today. So Maya, I would like to start with you.
Great.
Your work is at the national level.
Mm-hmm.
And so you have a very solid grasp of the nation's legal ability to protect our environment. Can you tell us what a federal law such as the Clean Water Act, how well it has worked in stopping water pollution?
So actually, the Clean Water Act has been quite effective at limiting pollution, limiting environmental degradation, limiting the devastation of our wetlands. But our federal laws, Clean Water Act and others, have not done the job fully and completely. There are still a lot of gaps. So under the existing under all existing federal law and state law, it is not actually illegal to pollute the waterways, the rivers, the streams, the groundwater, to fill in wetlands and inflict incredible harm, or to inflict significant harm on ecosystems or waterways, or cause air pollution, right, and have serious environmental ramifications of all kinds. The limiting factor is you have to go to the right agencies, and you have to get the right reviews, and then the right set of permits that will in fact provide the permission to pollute and damage the environment, but it does limit it. And it limits it very significantly. So what we have seen through the passage and the implementation of the Clean Water Act and other really iconic and important federal laws is that they have done a very significant, meaningful job at reducing environmental pollution, degradation, and harm. They haven't gone far enough. We still have serious environmental problems despite these laws being in place, but we are certainly in a better position now today than we would have been in the absence of our federal laws, right? So it's a lot of good, but there's still a lot of problems and that need to be addressed, which of course is why the Green Amendment movement and the Florida Right to Clean Water are so powerful and impactful.
So last week, the Supreme Court made a ruling. It was in the Sackett case. Can you tell us what we need to know about that decision? What's the significance of that?
So what the U.S. Supreme Court did was really change the wetlands that the federal government is able to regulate, is able to protect to the degree that they're able to protect wetlands from filling projects, development projects, pollution, and all other kinds of devastating harm. There's been a lot of debate over many years over what wetlands the Clean Water Act actually allows the U.S. EPA and the U.S. Army Corps of Engineers to subject to their permitting process and therefore put in place critical protections for. Again, not everything we need, but a whole lot of what we need. But there has been a pretty broad definition over the years, and one that has really been focused on what are the ecological factors and values that determine whether or not an ecosystem is a wetlands, is a river or stream, right? Or a marsh, or is uplands, is just solid land that's not subject to environmental protections under the Clean Water Act, is not ecologically a wetlands, and therefore not subject to Clean Water Act protections. But what the Sackett decision did was it really, frankly, took the definition out of the hands of science and regulators, and it just tried to create a bright line that really focused on, frankly, whether or not people can see standing water in this wetland area, and a definition that focuses on the proximity to easily recognized waterways like rivers and streams and lakes and bays, right? And so what the court said is, in order to be a regulated wetland under the Clean Water Act, you really needed to be able to essentially, I mean, everything's very nuanced, but essentially be able to see water, standing water there. And they used a description to say that you needed to really have enough water present so that one could not easily tell where the neighboring river, stream, or other waterway ended and the wetland began. So if you have to be able to see that standing water, essentially, if you have to be able to see that water, then you're really taking out of the realm of regulation all sorts of areas that ecologically are absolutely wetlands, right? Their soils are saturated. They have the plant conditions, they have the ecological conditions that make them scientifically wetlands, but they are not now going to be legally defined as wetlands under the Clean Water Act, and therefore evade the obligation to get a permit from the U.S. Army Corps of Engineers or the U.S. EPA in order to undertake damaging activities on them.
So my understanding is that this is going to open up millions of acres to potential harm. Millions of acres of wetlands to potential harm. Now, you know better than anybody else, there are 3 states in the nation that have green amendments.
Mm-hmm.
Are they going to be impacted differently from this Sackett decision than the other 47 states?
So one thing you are 100% right? We are going to be now opening up millions of acres. And I think it's really hard to calculate. But it is a massive area that are actually ecologically wetlands that will no longer be subject to Clean Water Act protections. And I think it really bears noting that at the state level, many states for many years have counted on the federal government and the Clean Water Act to protect the wetlands within their states. And so actually they have not invested or passed the laws, the regulations, or invested in the agency resources necessary to really take on the challenge of protecting wetland areas, thinking that in no small part the federal government was going to do it. So now we've wiped away that federal protection. And so now in these states that don't have this higher state level protection, we've got this great big legal gap where there is nothing sort of to step in and provide essential protections now that the Clean Water Act protections have been wiped away. But if a state has a green amendment, right, we have 3 states that have green amendments, Montana, Pennsylvania, and New York. And we're going to have to see how it plays out. But in these states, each state has different language, but in these states, the people have a right to clean water and healthy environments. And so I would anticipate, to the degree that there is a gap in wetlands protections at the federal level and then also at the state level, that we are going to see more and more communities, environmental organizations, state government, local government, turning to the constitutional right of the people to clean water and a healthy environment to try to fill the void that has now been created and be able to support decision-making that protects these wetlands from harm, because the wetlands are essential for protecting the quality of our waterways, right? Wetlands are essential for protecting water quality in rivers and streams and groundwater. Wetlands are essential for protecting communities from flooding and flood damages, because they're this massive sponge holding area for water that would otherwise flow out and be dumped on downstream communities, subjecting them to growing flooding and flood damages, which of course is very unsafe. Wetlands are critical for supporting ecological systems that are important environmentally, but that are also frankly important economically, right? Like states like Florida really rely upon their healthy aquatic ecosystems, not just for their environmental values, for their economic values. And so to the extent that Green Amendment language gives people a right to clean water and healthy environments, my expectation is that at the state government level, even at the local government level, we are going to see government officials relying on the constitutional right of the people to a clean, safe, and healthy environment, relying on the trustee obligation to protect the natural resources of the state for present and future generations, to support protective wetlands actions and decisions, while hopefully those state government legislators are working to pass the legislation and the regulation that is going to be necessary to sort of step in and help fill the void. And the passage of that legislation and regulation is most likely going to be grounded in the existence of those constitutional green amendments, right? But it will take time. It will take time, but that is my expectation as to what will happen. One of the beautiful things, so in the 3 states where we have green amendments, that we don't specifically see wetlands mentioned, But we do see that in the Florida right to clean water, which is going to be extremely helpful for Florida and Floridians to use the Florida right to clean water Green Amendment to help fill the gap that's been created by the Supreme Court in this rollback, this extreme rollback of wetlands protections in how that term is defined under the Clean Water Act.
Thank you, Maya. I would like to bring in Jane at this point. Jane, can you speak specifically about how Sackett will affect Florida's wetlands in the short term and the long term?
Sure, and thanks. It's always so great to be on a platform with Maya. I love hearing her explanations and her passion. It definitely comes through. So I am going to attempt to share screen right now. Let's see here. And I'm getting a request from a Jameson Herald for remote control of my screen, which I'm going to decline. So let's talk a little bit about Sackett versus EPA. What now? How does this affect Florida? I think one of the first gut reactions that a lot of attorneys had across the nation was states should quickly strengthen their own laws when it comes to wetlands regulations, right? We saw this statement from the NRDC. We saw it from, a very similar statements coming out of Earth Justice and numerous other environmental organizations across the nation. And why is that? Because the case will determine whether wetlands do or do not deserve federal protection, but nothing prohibits states from strengthening their own state wetland protection. But the question is that a realistic expectation here in the state of Florida? And yeah, I put this little comment in that, yes, I took all these photos because I happen to traipse around our beautiful state with my two sons all the time. So it was really easy for me to assemble a group of slides that reflect our beautiful state. So moving on, the state of Florida has already assumed 404 authority. This was a real big push for a long time, most especially by the development community here in Florida. But it happened back in 2018. House Bill 7043 basically granted to the Florida Department of Environmental Protection to basically take over the authority that EPA currently has with 404 permitting under the Clean Water Act. And so after that piece of legislation passed, it was really pushed through by the development community. The state rulemaking started and was finalized after a ton of public input, thousands of comments. It was finalized back in July of 2020. In December of 2020, FDEP officially assumed the responsibility, the authority to issue wetland permits in the state under Section 404 of the Clean Water Act. Now, what does that mean exactly on the ground? There was a lot of, hand-wringing and panicking over this because at the time, if you recall, Governor Rick Scott had completely gutted DEP from a resource standpoint. It was basically really functioning on a shoestring when it came to resources like personnel. And so there was a lot of concern that there was just no way that this state environmental agency was going to be able to take on the additional significant regulatory burden of basically issuing wetlands all over the state of Florida. And so there was real concern about a resource standpoint, but there was also a real concern about, the shorter review periods, shorter comment periods. There were much tighter deadlines. And the whole purpose of the 404 assumption was basically to provide a streamlined permitting procedure where you had basically both the federal and the state requirements addressed by one agency instead of having to go to both the feds and the state. And it basically was, heralded as like one-stop shopping, just kind of trying to reduce that bureaucratic red tape that developers often complain about here in the state of Florida and nationwide, quite frankly. So the state of Florida is one of just very few states that have assumed 404 authority. And there has been, you know, some hiccups in terms of implementing the assumption of 404. I will note that the Army Corps of Engineers still maintains authority over retained waters. And so what are retained waters? These are large water bodies that you can easily find through this very helpful website that FDEP has launched. If you click on this, or at least copy and paste it into your web browser, you can pinpoint your exact location and figure out through purple hatch marks, you know, on a map, what exactly constitute retained waters. What you're going to see if you do that exercise, which I highly encourage you to do, you know, I'm a big map lover, right? And so I love all these interactive GIS maps and, you know, plugging in my zip code or my address and, you know, going on a very granular level to see what's going on in my neighborhood. And then just, you know, checking out everyone else's yards and, oh, I didn't know they had a pool. So it does get quite that granular, but it's really helpful in terms of understanding, you know, what the retained waters in your jurisdiction might be. And what you're going to see, I think this will surprise many of you, is what is not included in terms of wetlands. And someone, I believe it was Rhonda Ruff, big fan, posed the question of whether or not navigable waters, that phrase within the Clean Water Act, is kind of a fatal flaw. And I would say at this point in time, yeah, I do think it is kind of a fatal flaw in the Clean Water Act, because it really kind of limits the scope. You know, the Clean Water Act was drafted and implemented decades and decades ago when things were very different. Our understanding of wetlands, the hydrology, the geography was much different. So I think it just deserves a more nuanced approach other than just navigable waterways. And I do think that is probably one of the flaws of the Clean Water Act. But unfortunately, you know, we have not addressed that situation. Anyway, I would highly encourage you to check out this FDEP map, because it's a good resource. So what can we expect on the regulation of wetlands in Florida in the wake of the Sackett versus EPA decision? Well, history is a good indicator here, right? So under the Trump administration, the Trump administration pulled back protections for streams and wetlands under a revised definition of the waters of the United States, which would be called WOTUS. Now, federal judges vacated that rule and sent it back to EPA. But what is important to note here, that after the Trump administration came out with that, no pun intended, watered down version of what WOTUS stands for, Florida continued to apply the narrower Trump definition in its permitting decisions about wetlands, streams, and other water bodies. And I think that's really instructive in terms of how we're going to move forward. We already have kind of a sneak peek, if you will, in terms of how this current administration is going to handle this under Sackett versus EPA. They're going to take the path of least resistance towards permitting the development of wetlands. I think that's pretty obvious from what we've seen just in the very recent history of the current administration. And so what wetlands are most at risk? Those shallow seasonal wetlands. And a couple of you commented very accurately in the chat that you know, you can have a wetland without standing water. You have seasonal wetlands where it's going to change based on whether or not you have a rainy event. So I decided to pull a little just kind of case point here of example of wetlands that would likely be permitted for destruction in the state of Florida. And what you have here, this is fairly recent, 2021, a piece of property in Plant City that had just close to 3 acres of wetlands. And you can see here, you know, it's not contiguous to any other functional ecosystem. It's a very, you know, we're going to be the first to admit it's an isolated wetland. But I have to ask, does that mean it has no ecological value? No, So, you know, this particular parcel, the Florida Department of Environmental Protection made the decision that it did not need to get a 404 permit because it was an isolated wetland in upland habitat. It was not a navigable waterway, and so no permit needed. And my problem with decisions like this is, you know, these are the incremental little paper cuts that are slowly killing Florida piece by piece by piece. We see it all around when we drive around and we see the destruction of our habitat, you know, bulldozers clearing out large swaths of land. We do not need any more watering down of our existing regulations. And I have some serious concerns about how Florida is going to implement the 404 permitting in the wake of the Sackett decision, but we will have to wait and see. Hopefully they will take the higher ground. Again, no pun intended. But we've got to kind of wait and see on that one. Now, there was Joe, you mentioned that there's been some additional cause for concern at the state level, so I'm going to launch into that very briefly because this has been kind of a game changer for us in the public interest land use arena here in Florida. Governor DeSantis last week on Wednesday signed into law Senate Bill 540, the local government comprehensive plan law. And I need to just tell everyone that although I work as the policy and planning director and lead lobbyist for 1,000 Friends of Florida, I am here today serving very passionately in my personal capacity, not on behalf of 1,000 Friends of Florida. But I have a lot of working knowledge on this bill because not only did I lobby against it, but I proposed several amendments to try and soften the blow of this bad bill. So let me talk a little bit about what this bill is. I have characterized this as the death knell to growth management in Florida. The sponsors are Representative Wyman Duggan, is featured there in the top. He is a land use attorney for the law firm of Rogers Towers in Jacksonville with a lot of developer clients. And Senator DeSigley there on the bottom, not an attorney, but basically the bill stands for the proposition that a prevailing party will be able to recover all of their attorney fees in a comprehensive plan amendment challenge. And the bill also, well now law, strips down the legal basis for a comprehensive plan amendment challenge. So let me talk a little bit about, you know, how does it limit the basis for a comprehensive plan amendment challenge? And then for those of you who don't know, you know, comprehensive plans are basically like the constitution for each of our local governments, whether you live in a city or a county, not within a municipality. Every single local government, all 67 counties, well over 400 cities, they each have their own comprehensive plan. And it has goals, objectives, and policies. It's an awesome planning document, but only if it's followed. And unfortunately, what we've seen is a real uptick in the comprehensive plan being amended time and time again to accommodate development throughout the state of Florida. And unfortunately, there has been a split between the Florida courts in development order challenges and comprehensive plan amendment challenges. One is very restrictive. It limits the scope of challenges to use, density, and intensity only. And the other one out of the first TDCA is broader. It can include all sorts of challenges to a development, including things like pretty critical right now, like hurricane evacuation. Things like that allowed to be challenged under this bill. And unfortunately, the bill settled the conflict by resolving it in favor of a more limited scope. So it's really unfortunate on a couple different levels. But the problem that I have with it the most is the prevailing party attorney fee provision. If you've ever had to hire an attorney for a comprehensive plan amendment challenge, you know that it's an expensive process. Imagine being on the hook, not only for your local government's attorney fees, but also the attorney fees for the developer attorney who intervened in the litigation. This may stun some of you, but I have often found that those developer law firms charge at rates that would just kind of blow your mind, you know, $800, $900, I've seen $1,200 an hour. So if you can imagine a comprehensive plan amendment, if you lose that challenge, you are on the hook not only to pay your attorney and the local government attorney fees, but also the developer fees. And you're looking at, hundreds of thousands of dollars potentially. Most people, as much as they care about what's happening in their community, they don't care quite enough to wipe out their entire life savings, right? Understandably so. And so what the effect of this legislation is going to have a significant chilling effect on the ability for Florida citizens to engage in the comprehensive planning process, because they simply are not going to embark on that litigation because of the financial chilling effect. So I do have some good news, but Joe, I know you had some questions before I launch into my one tiny little bit of good news. Uh-oh, you're on mute.
Sorry, I had some background noise. Were there other damaging bills that were passed during the past legislation session?
Yes, quite a few. I mean, I could talk, and I have in my capacity with 1,000 friends, at length about the number of damaging bills. And quite frankly, I would direct people towards that resource, the 1,000 Friends archives, its old webinars, and I would direct you to go to our post-legislative session wrap up on some of those really bad bills. This has been an extremely challenging session, and not just the culture wars in the state of Florida, but also for the environment and comprehensive planning in the state of Florida. And there's you might wonder why I've been asked and invited to, talk about land planning, but there's obviously a very considerable nexus between how we develop our land here in the state of Florida and our impaired water quality issues. So with that, I am going to mention the one bit of good news that I have from this legislative session. And there's others, but I'm particularly proud of it. This was basically shaking the dust off of a very old statute in the state of Florida, the Area of Critical State Concern statute. There are currently only 5 pieces of property throughout the entire state that have this designation. And this past legislative session, we were able to successfully get this bill passed with incredible bipartisan support all through every single committee stop and the House and Senate chambers, which designates 16 miles of the southern Brevard Barrier Island as an area of critical state concern. And that's really important because this barrier island serves as a prime sea turtle nesting habitat. It's where the RTCW park is, if any of you have been there. And it also, the barrier island fronts the Indian River Lagoon, which has suffered just tragic loss in seagrass beds, resulting in thousands and thousands of deaths of manatee. So hopefully with this new designation, we can see some tightening up on how the regulation over, the septic systems that are still in place on the barrier island get converted over to central sewer. Seagrass planting is going to be undertaken before they can ever lose that designation. So I think this was, like the Right to Clean Water campaign, this was kind of a creative approach. And I think we're going to increasingly have to get creative as we look on how to solve Florida's environmental problems, because it's definitely a challenging landscape right now.
Jane, given the Sackett ruling, given 540 and some of the other legislation that was passed, do you see this as making a Green Amendment, our right to clean, healthy waters in Florida, ever more important?
Absolutely, because we've just lost a significant tool, and I can't emphasize this enough, that the ability to not challenge comprehensive plans because of that financial risk, that tool is really effectively off the table now. And so when we limit the ability to have those channels, those points of entry for challenging just reckless and irresponsible development in the state of Florida, we increasingly have to resort to more creative means. And the right to clean water amendment is definitely squarely within that category of an alternative way to solve the problems that we have. So it's a critical tool that I just genuinely hope we can get it across the finish line, because we don't have those tools available that we historically had.
Thank you.